everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're talking about changing parenting arrangements. And that's something that happens inevitably. Because the only thing we can be sure of in life is change. And of course, at the time where parenting plans are made, child arrangement orders are made, we don't know how things are going to evolve. Children grow up, children have new needs, parents meet new people or make decisions that relate to their life but that impact the children. So inevitably, these arrangements need to change over time. And so I wanted us to talk a little bit about how that works in practice. And to do that, I've invited Marc Etherington. And Marc is a legal director and collaborative lawyer as well at Rayden Solicitors in London. Marc has experience on all areas of family law, but he's especially known for his work on children matters with complex issues such as high conflict and domestic abuse. He's also known for his technical finance work for those who are experiencing divorce and separation. Welcome, Marc. It's great to have you today.
Thank you very much for the invitation, Chloe. I really appreciate it.
I'm really looking forward to this conversation because it's a topic that comes up time and again. As I said, things very rarely stay the same over the long term. And so the question of amending arrangements inevitably comes up. I think maybe before we dive into the mechanics of it all, it's probably worth just taking a minute to think about or to explain the difference between a child arrangement order in England and Wales and a parenting plan and why we're going to be talking about one and not the other.
Yeah, so look, a parenting plan is when two parents separate, they set out on a plan what the arrangements are going to be for the children moving forward. And it may not just cover the living arrangements, but it may cover issues about decisions around school, about health, or any other aspect of the child's welfare. A parenting plan is not approved or ordered by the court. So effectively, it is a record between the two parents. Inevitably, if you do have a parenting plan and things don't work out and you do need some assistance, for example, from a judge at court, then a parenting plan is a good record of what was previously agreed. So that provides some background to the judge. A child arrangements order is a court order. So that will regulate who the child lives with and what time they spend with the other parent. You could have a shared child arrangements order whereby it says that the children live with both parents and then divide the time, or it may say that the children lives with one parent and yet spends time with the other, as I mentioned earlier. So those are the main differences between a child arrangements order and a parenting plan.
Right. Very helpful, thank you. So with one being legally binding and the other one being more of what we call a gentleman's agreement, I guess, the process for variation is different, right? Because if it is just an agreement between the parents as a parenting plan, they can just sit down and amend it as need be. With a child arrangement order, there's an actual formal process to require a variation. Is that correct?
Not necessarily. So
Okay.
obviously with a parenting plan, if they want to change the arrangements, they can just do that. And it would
Mhm.
probably be sensible then to produce a new parenting plan.
Mhm.
Now, a little tip, what you could probably have in the parenting plan is to say any other arrangements or agreements as agreed between the parents. So effectively, you're confirming we are going to follow this agreement, but if we want to make any decisions, we can do so, provided
Mhm.
it is agreed by both parents. And the parenting plan may say, in that event, a new parenting plan will be drafted, or any agreement will be confirmed in writing, and that could be by email, WhatsApp, however you want to do it.
Yeah.
With a child arrangements order, if you do have a child arrangements order already in place, what often happens in those orders is that it does say, normally at the bottom, any other arrangements as agreed between the parents. Because what judges do not want you to do, really, and it's about resources of the court as well,
Mhm.
is if you want to depart from the child arrangements order, that you have to make the expense of going to court again simply to change something that you've already agreed. So I
Yeah.
think the idea of that part in the order is to say, look, if you between yourselves agree an alternative arrangement, then go ahead and do it. And maybe how you want to record that again is making sure that that's then converted into a parenting plan, or again something in writing just to record, what changes you've agreed. The issue obviously becomes about maybe going back to court is if you can't agree
Yeah.
what arrangements need to change.
And so in that kind of scenario, then, where there is a need to go back to court and to request an official variation, what are the options available to the couple to resolve that problem?
Well, it does depend on the circumstances of the case. Look, before you even think about maybe varying a court order, do explore all non-court dispute resolution options, as we call it, because the court process really should be a last resort. And so, for example, mediation may be a positive way forward, a roundtable meeting. It may require just some communication between legal representatives. There is also a process called arbitration. So if you do need somebody to make a decision, it doesn't necessarily have to be the court and a judge. Potentially, it could be an arbitrator, provided both parents agree to adopt the arbitration process. Inevitably, if those options are not explored or agreed by both parents, then the last resort is to make a court application.
Yeah.
And the process to do that effectively is that you would have to file a fresh C100,
Hmm.
which is the application form you would submit when making an application related to children to the family court. At the moment, at the time of releasing this podcast, the court fee for that is £255. And although certain people may be exempt from paying a court fee depending on their financial circumstances, and then the court will receive the application. They will have attached to the C100 a copy of the previous order, and
Yeah.
then you will set out in your C100 why you think the arrangements as previously ordered need to change.
So how do you demonstrate that a change is necessary and that you're not just wasting the court's time?
Yeah, so look, the legal position is the child's welfare is the court's paramount consideration. And if you believe that a change of the arrangements is in the best interest of the children, then
Hmm.
that should be at the forefront of your mindset.
Yeah.
Now, if you've just been through the court process and an agreement has been reached and a decision has been made, the general guidance I give to clients is that even if you have concerns about the arrangements as to how they would work, I
Hmm.
would say at very least 6 months, you need to give this arrangement time to bed in and to
Yeah.
see how the arrangement works. Now, look, certain situations may arise unexpectedly when you do have to go back to court more urgently. I don't know, perhaps one of the children all of a sudden has an additional health need, which
Yeah.
makes the arrangements impossible, or there's certain circumstances regarding one of the parents' employment situation, which again makes it not possible for the arrangement ordered by the court to continue. But
Yeah.
as I said, generally speaking, I think you do have to give it some time to bed in, see if the arrangement works, because otherwise, if you do simply make an application far too quickly and not child focused, you're probably going to get quite an unhappy judge when you go before the
Yeah.
court.
If you're trying to demonstrate that it's in the best interest of the children to change the order, you also need to have actually tested it and be able to evidence that it isn't working for the children. So they go hand in hand.
Yeah.
And once you apply for a variation, can it be done quite quickly? For example, if there's a need to make a decision regarding schools or anything of the sort, or how long does it typically take?
Well, the application to the court can be dealt with quite quickly,
Mhm.
provided, you have explored non-court dispute resolution. And it's exactly the same process if you was to make a fresh application without any
Yeah,
existing child arrangements order. You have to demonstrate to the court that you have attempted non-court dispute resolution.
yeah,
And that would normally be verified by a mediator who is a certified accredited mediator who would confirm to the court that attempts have been made to explore other ways to resolve the matters, for example, attempting mediation.
Yeah.
And what should happen at one of these meetings with a mediator, which we call a MIAM, is that the mediator should discuss with you all the options that are available to you to resolve matters without going to court. Once you get through that, and if it is a court application you need to make, then yes, you can make the application quite quickly. The biggest challenge, however, across the country in England and Wales is the resources of the court. And we are seeing cases where, yes, you can make an application, but if you do make an application, nobody at the court, a legal advisor, for example, won't consider your application for, say, 3 months, for example, due to the backlog. And even when a legal advisor considers your application, they may make some directions that need to be complied with before a first hearing. So, I think in reality, what's happening now, from the point you make your application, may not be in a court hearing for 6 months. That's
Yeah.
potentially what could happen.
It's yet another argument for trying to negotiate out of court, a better way to do it, because it also gives you that speed that you wouldn't get through the court system.
Yeah, absolutely. And look, for me personally, it's really hard to advise clients about the delays through the court system. I think as a family justice system, we're not sufficiently meeting the needs of children at the moment, because I think speed is very important for children,
Yeah.
certainty. And, if you're waiting for a decision to be made, or even just to have a court hearing over several months, it just causes a lot of instability to the children and to the parents. And the problem is as well, if you have that uncertainty between parents, that can impact on their relationship towards each other.
Absolutely.
It could increase the conflict, and then the children are exposed to that conflict as well. So I think there are real problems with the system at the moment.
Makes sense. So you touched upon it a couple of times where the paramount consideration is what's best for the children. Rarely do one of the parents, or do you find yourself in a situation when one of the parents truly has the children's best interest at heart and the other one's just being selfish? They honestly both believe that they've got the children's best interest at heart. So how do they go about evidencing that, and how does the judge decide?
Yeah, so I think inevitably when you file your C100, you have to
Mhm.
set out clearly why you are asking the arrangements to change. So I
Yeah,
think you have to set out clearly why the existing arrangements are not working
yeah,
and why the alternative arrangement is going to work. The
yeah,
difficulty at the initial stage is that you don't have permission from the court to file particular evidence.
yeah.
But obviously, directions will be made by the court at a later date. But certainly, I would suggest communication with, say, the children's school to see
Yeah.
how the children are doing at school, because sometimes if arrangements are not working, it is picked up by the school, and it may be shown in school reports, for
Hmm.
example, in terms of their performance or attendance at school. Potentially another way to maybe get an expert input into the current situation is to instruct an independent social worker. Now, you don't necessarily need an order from the court to do that
Yeah.
before you make your application. So, for those of you who have gone through the court process before, you would be familiar with CAFCAS,
Hmm.
which is essentially a social worker for the court that provides an information to the court to assist them in making a decision.
Yeah.
Now, the advantage of an independent social worker who you would pay privately is that they would have time to spend with each parent to understand their reasons and concerns with the existing or new arrangements, to speak to the children, to understand their wishes and feelings, provided they're old enough to communicate with the school and any other services that the children are working with at that particular time. And they would often provide some recommendations to the parents as to how to move forward.
Yeah.
Something like that may be quite useful, because you have got somebody completely independent looking at this from a fresh pair of eyes to say, look, I've looked at the situation and I think this is what needs to happen. So that
Yeah.
may be an alternative way, but inevitably, if you do make an application to the court will consider your application, and you will be expected at some stage, most likely, to file a statement, which is
Hmm.
your evidence to set out why the arrangements should change.
Yeah. And then, and are there any other reasons aside for it not being the best decision for the children? Are there any other reasons why a variation request might be rejected?
It's well, look, I think inevitably because the welfare of the children is the court's paramount consideration, that
Yeah.
that is essentially the sole decision. And as I think I touched upon earlier, I think if you just make an application straight after a decision's been made, it's just going to be shut down straight
Yeah.
away. Inevitably, each parent has a legal right, so to speak, to make an application to the court if they want to do it. But just because you make an application, it doesn't mean that the court is going to change the arrangements. Now, look, I've dealt with cases in the past where I have made variation applications and they have been successful. And it
Yeah.
could even be just changing one day. So it may have been, for example, the children were living with mum during the week and father seeks one overnight stay during that week, and the court grants that and allows the
Yeah.
additional nights between the children and their father. So the
Yeah.
arrangements don't have to be drastic, they can be quite minor. But of
Yeah.
course, if you are making a court application and going through the stress of proceedings and potential legal fees as well, I think you just have to balance it really as to what is the best way forward. But as I said earlier, provided it can be agreed, there are other ways available to avoid court if at all possible.
And so the concept of welfare of this of the children, just like the concept of fairness with financial settlements, it's very subjective, right? Are
Yeah.
there specific elements that weigh more heavily, in the balance when you're trying to prove the children's welfare or to prove that your decision or your suggestions in
Yeah.
that direction?
Well, I think what you have to go to is the welfare checklist because
Okay.
inevitably that is what the law looks at.
Hmm.
So if you are thinking about varying the arrangements for the children, what you need to think about, provided they are of a sufficient age and understanding, is what the wishes and feelings of the children are. Be a
Yeah.
little bit careful about that because sometimes children want children will say to parents what they want to hear. So they may say, X is the outcome I want with one parent, and Y is the outcome with another with the
Yeah.
other parent. So be a bit careful about that. Also, understanding what their physical, emotional, and educational needs are. So, one example where the variation of the child arrangements may be suitable. Let's say one of the parents has decided to move house and they are
Yeah.
a further distance from the school, that's causing problems in terms of the traffic and getting to school, perhaps the children not getting as much sleep and time to get
Hmm.
ready for school as they should be. Again, that could be a possible consideration. Another factor under the welfare checklist is the likely effect on the child of any change in circumstances.
Yeah.
Generally speaking, children like stability, consistency, and certainty. And so children can adapt to change, but they should only have change imposed upon them if they are able to manage that and it is in their best interests. And then obviously other factors the court may consider is the age, the sex, any background characteristics of the child, any harm or
Okay.
risk of harm that the child is suffering, which maybe actually I'll come on back onto because there's quite an important
Yeah.
subject
Yeah.
about that, and how capable each of the parents are in meeting the needs of the child as well.
Okay. So do you want to revisit that point you were just making?
Yes, because I've had a number of cases where there is an existing a child arrangements order in place,
Yeah.
but all of a sudden welfare issues arise, or
Yeah.
let's say domestic abuse. And just to be clear, domestic abuse doesn't just mean physical abuse, it could be emotional, psychological, or financial abuse.
Yeah.
So if you have an existing child arrangements order in place, and you are of the view that the children are at risk of suffering significant harm by
Hmm.
the arrangements continuing as they are, for example, continue to spend time with a particular parent, what you may have to consider is effectively making an emergency application to vary the child arrangements order. Now, my advice would always be is that, look, you should not be breaching any child arrangements order unless it's an absolute emergency to do so. And often that type of situation, which may support such a application, could be that if there is involvement from the local authority, so children's
Yeah,
services, and they have raised concerns, you have something in writing from the school raising concerns about what is happening, or any other form of evidence like that that you may think could be quite useful. So, for example, maybe you've been working with a domestic abuse charity or something like
yeah,
that, and they have assessed you as being at high risk. And this isn't just abuse towards a parent, but it's also abuse towards children.
yeah,
And I think especially in some cases where there's been a history of domestic abuse during the relationship, both parents are very keen, despite that happening, to try and ensure the children spend quality time with both parents. But it then turns out that the abuse carries on post separation, and it could be concluded by one parent that actually, I thought this behavior was going to stop once we separated. It's continuing. I
yeah.
need to take drastic action. But I think in those situations, it's really important you do get legal advice so you do understand and make sure you take the right steps. Because if you do stop the contact between the children and a parent, and it's then determined that that was the wrong step to take, there could be significant consequences
Yeah.
as a result of that. So, yeah, you have to be very careful, but look, it can happen in very extreme cases.
Actually a really good point because you often hear people saying, well, my kid didn't want to go see their mom or their dad, and so I let them not go, or I didn't respect the terms of the order because the child didn't want to. How does that get dealt with by the court?
That's really difficult. It's a really difficult issue because there's always an assumption, especially with, say, the parent that is not seeing the child, that the reason a child is saying, I do not want to see you, is because that child is being coached in some
Yeah,
way by the resident parent. Now, that could be the case, and it may require investigation by the court to determine what has happened, to understand
yeah,
why is this child behaving in that way. But there could be other reasons as well. It may be that the quality of the time between the non-resident parent and the child is not of good quality. The child doesn't enjoy it. It could
yeah,
be that. It could be the parental conflict, and the child feels that in order to stop that parental conflict, they need to stop spending time with a particular parent. There can
yeah,
be several issues or reasons why a child doesn't want to spend time with a parent, but inevitably it is a balance because we have children. They say, I don't want to go to school today. I don't want to go to the dentist. You make them go.
yeah,
So there is that side of it where they need to go anyway. And remember, a child could be suggesting to a parent that they don't want to see a parent because they think that is what's going to make that particular parent
yeah,
happy. So there's that consideration. But inevitably, if a child starts becoming very difficult in their behavior, I think especially when you get children, say 10 years old and above, who are saying, I do not want to go, they start locking themselves in the bathroom or their bedroom. I've had cases before where children even start harming themselves. I think when you have quite drastic behavior by children, that they are clearly unhappy about something, it's yeah, I think you have to take that into account. But again, I think it's a gut parent reaction as to what is going on and getting some legal advice and maybe support from professionals as well to try and ascertain what is actually going on in the
yeah.
mind of that particular child.
Yeah, I would think about that. Child inclusive mediation can be a really good approach as well because it gives a neutral outlet for the child to speak to. It takes away that bias of I'm telling mom what she wants to hear, or I'm telling dad what he wants to hear, and hopefully makes them able to say what they really mean and what they really want to say.
Yeah, absolutely. And have the voice of the child is really important. And look, the voice of the child doesn't mean the child makes the final decision.
Yeah,
Obviously, if they get older, it has greater importance. But I think the opportunity to have the voice of the child heard much earlier during the separation process would be quite important.
Yeah.
So yeah, you're right. The mediation, child inclusive mediation would be a really good way in order to promote that. And I am involved in a new scheme at the moment
Yeah.
whereby it's not mediation, but we're exploring ways as to how the voice of the child can be heard much earlier in the process,
Yeah.
maybe where on a without prejudice basis, both parents and both parties' legal representatives effectively sign an agreement for a professional who would be a mediator who is trained to speak to children, to
Yeah.
speak to that child, and then to give feedback to the parents in the same room together what the child is saying. So that may be suitable in cases where, for whatever reason, mediation is not the right option, but you
Yeah.
still want to come back to the parents as to what the voice of the child is.
Yeah. Yeah. They can be really creative solutions. I like the idea. I think there's another element that, we often don't take into consideration, but it's giving the child an opportunity to express themselves as well and to be somehow part of the process because they feel very much like it's happening to them. And just that opportunity to be heard with the very clear understanding that they're not making the decision, but that their voice matters. That can be really powerful psychologically for the children as well.
Yeah, and I think a lot of feedback from adult children, children who are now adults and have gone
Yeah.
through the separation process, is that I was never listened to. I was never given an opportunity to have my say. And
Yeah.
so I don't think we should disregard that. But it's tough. It is tough. Being a separated parent is a journey on its own, and it is difficult. And if you agree arrangements and then you think it's over, and then circumstances change where you now have to vary the arrangements, it does happen. But inevitably, look, especially if you agree, say, a child arrangements order when a child is, 3, 4 years old, that's going to look very different to when a child is 11 or 12 years old. And so you will find these situations come up where you have to have a conversation. But I think from my experience, what's really important is not only you say what you think's in the best interest of the child, but you do need to listen to what the other parent says and try and balance it up and come to the right decision.
Absolutely. And back to that point you made earlier on around non-court dispute resolution options where we actually speak to each other rather than get somebody else to make the decision.
Yeah, absolutely. And also, look, you don't want a stranger to make the decision, because what you may find is you want the arrangement A, the other
Mhm.
parent wants arrangement B, and the judge makes arrangement C. At
Yeah.
least by all of the other non-court dispute resolution options, probably except arbitration,
Yes.
is that you have some control as to the outcome.
Yeah.
And that's really important, because actually, if everyone has their say on the outcome, on the arrangement, it's more likely to be complied with as well.
Absolutely. Absolutely. So just to wrap up, Mark, I'd like to finish the podcast with, I guess, a summary. And from your perspective, what would be your 3 tips to a parent who feels that their child arrangements are not working and that they need to be varied?
Yeah, so my top 3 tips would be: number one, are you able to communicate with the other parent to
Yeah.
have this discussion in a safe way?
Yeah.
And if not, what non-court dispute resolution options can you explore
Yeah.
to reach the agreement in order to vary the arrangements?
Yeah.
Option number 2, at the forefront of your mind, think to yourself, are these arrangements changing in the best interest of the children?
Yeah.
Weighing up all those factors that I mentioned on the welfare checklist. Is this
Yeah.
best for your child, or actually, is it just more convenient for you? So that's something I think you have to be quite honest about yourself and to think about that. And then option number 3, if you do have to make your court application, do set out very clearly on
Yeah.
the C100 application why the existing arrangements are not working
Yeah.
and why the new proposed arrangements would work. Because CAFCAS will do an initial safeguarding letter when your
Yeah.
application is placed before the court. They will see what you say on your C100, and they will want to talk to you about that when they speak to you ahead of the first hearing. So they're probably my top 3 tips.
They're great tips. Thank you so much, Mark. It's been great having you. Thanks for joining me today.
No, absolute pleasure, and yeah, I really appreciate it. So I hope your listeners do find this very useful.
And they can reach out to you if they need any help.
Of course.
Thanks so much, Mark. Have a good day.
You too. Take care.